You are now live.
We are now live, and this is Senate Finance. And I'm going to call this meeting to order. It is March 11th. And today we have two bills, as far as I know, left on our calendar that we're going to either get out or not, but this is crossover. And then we're going to take a quick walk through the Act 250 changes that sent to us. And then we've got an amendment to S53. Apparently the tax department thinks we need to adjust the wording in the transition from Joyce to Finnegan. So it's technical, but Abby will be in and help us with that choice. So, and I have bills.
The Irish are very litigious.
Yes.
Sorry?
Overall,
The
lawyers.
Irish are very litigious.
Yeah.
Careful. Let's see. No, that is not the one we're taking. Yes, it is. Okay, I do have the bill.
Senator Cummings, you have 3 documents on S-166.
I do. Okay, yes. And there is. So we have the bill. And this is. So does anyone on that side of the table need that? This is Maria's third option. So you might like that. She's going to talk to us about. Okay. This is the poll one.
For us, I brought
Yeah, and one for.
one for.
Oh, okay, and this is another one. Great, by Maria.
And what you said at first, I thought this was a bill on poll watchers.
That's across the hall.
Oh, this is
What do we do? Just put them.
Or just put them in a pile here and they will clean up after us.
Faith would be lost without you. Turns out we're lost.
It would be buried in a pile of paper. Senator Sorokin, that's the
This is for Senate bill.
same bill. The paper's longer than the bill. Okay, so now I need to find my agenda. But Maria, I believe you are first,
okay.
right, on the agenda.
Great. So
The floor is yours.
terrific. Maria Royal with Legislative Counsel. So let me just take a moment to quickly explain the documents that you've, I believe, just been handed and that are also posted online under the committee's webpage under my name for today. So you have a new draft. I drafted it as draft amendment. I called it the third option. We haven't reviewed this language. It hopefully reflects some of the issues that came up before town meeting week, and we can go over that. I've also prepared kind of a comparison table that looks at S-166 as introduced, then the strike all amendment that was voted out of Senate Judiciary, and then finally this third option draft. And that's just so you can kind of follow along different iterations of the bill and then, see what you like or don't like about the specific proposals.
Okay.
And then I also posted, if you want to go back to look at the Senate Judiciary amendment, the specific language, I believe you have that as well. So those are the 3 documents, and it may make sense to go through kind of that third option first, so you're familiar with that, and then we can talk about other things that you might want to include or other earlier versions that you might like better. Does that make sense?
That sounds good.
Okay, and do you want me to share my screen and pull the document up here? Are you
I
comfortable?
think you've all got the document.
Okay, okay. So if you're looking at that third option, the statement of purpose, subsection A, is pretty much identical to what Senate Judiciary proposed. Just added some clarifying language. The purpose of this section is to protect the general public from harm or injury caused by unsafe construction practices related to utility pole attachments. So just adding that word construction. So subsection B is kind of the real substance of the proposal. And you'll remember the bill is introduced, asked the PUC to go through a rulemaking process to address some of these issues. Then the Senate Judiciary proposal just put the requirements directly into statute. This option is something in between. It basically asks the PUC to come up with a bulletin, although bulletin might not be the right term, maybe an order, the PUC to adopt an order that specifies requirements that would apply to pole attachments. So the purpose there was not quite as onerous and lengthy as a APA rulemaking process, but to the extent you might not be ready to have, exactly what you want in the construction contracts in terms of insurance requirements, it asks the PUC, and there's very prescriptive language about what they would be coming up with to do that after the legislation is passed. So that's for just, in terms of the process, I just wanted to clarify that. So then in terms of specifically what's in this bulletin or order, depending on, let me just also state that Kevin Gaffney from DFR reviewed an earlier version of this. And I just want to be clear, I did add that the PUC comes up with the bulletin in consultation with DFR. He actually didn't see that language, so I don't want to speak for the department ever, but I just wanted to make sure that that's just a little bit of a difference. So, and also the PUC did not provide input in this draft, and they are here today, but I just wanted to be clear about that. So in terms of that bulletin, it will establish best practices and insurance requirements pertaining to pole attachments subject to 3.700, so similar to the scope of the judiciary bill or proposal. And those practices and insurance requirements shall apply to attaching entities as defined in rule. So basically you're talking about a broadband provider or an electric utility if it's hanging its own fiber, contractors and subcontractors as deemed appropriate by the commission. So there's greater specificity, but the idea here is that those are potentially the three primary participants in the attachment process: the original attaching entity, its contractors, and potential subcontractors and third subcontractors, right? And that it's up to the commission to kind of apportion and decide who's responsible and what the specific requirements are. So we'll go through here because they are itemized in greater detail. With regard to the best practices, on line 15, specifically the bulletin shall establish best practices for the safe removal and disposal of construction worksite debris, as well as minimum commercial general liability insurance requirements for construction projects. And then more specifically, with respect to the insurance requirements, the bulletin shall include minimum coverage amounts, which may vary based on the size and scope of a project, methods for demonstrating evidence of insurance prior to the commencement of a construction project, notification requirements applicable to cancellation of a policy, reduction of coverage, or other change in coverage status deemed significant by the Commission, identification of persons who should be covered as additional insureds on a policy, requirements for extended coverage after project completion, if appropriate, and any other requirements deemed appropriate by the Commission to accomplish the purpose of this section. I think that covers most of the issues that have come up, and specifically the notification, being apprised if there's any change in status. There may be situations where actually entity should be named as an additional insured. So this attempted to at least itemize kind of the real areas of concerns with respect to insurance, and then also allow some discretion for the PUC to come up with, the very specific procedures and requirements. So then subsection C, you'll notice that both the bill is introduced. Is there a question?
It's, okay, yeah, then you
Third
make,
option. Just got it.
Oh, more than one page.
yeah, it's more than
Ah.
one page.
Okay.
Yeah.
I thought we had the second one, I thought we had passed it all out.
Everybody all set?
Sorry. Two more, you already read it. Okay, we're switching pages. It's
Okay.
Friday.
Okay, so I'm on page 2, subsection C now, and this is the third option, draft. And so subsection C, you'll remember that the bill is introduced and also judiciary's version tried to put this as part of or make it enforceable under the Consumer Protection Act because of some of the enhancements that come with consumer protection issues. And you did hear from the Attorney General's office, Mr. Chris Curtis, who spoke about it's not really a good fit, or it's a little bit different than what is typically covered under consumer protection. I did provide for you a list of, there are many instances where the legislature has specifically labeled content or specific conduct as a violation of the CPA. But I agree with Mr. Curtis that typically, there's more of a direct relationship between the consumer and the entity that's engaging in some kind of unfair conduct. So, here you have potentially a landowner who's not necessarily in a contractual relationship with the provider or subcontract. So I understand those concerns. So this attempts to, in subsection C, essentially provide most of those kind of enhanced penalties enforcement mechanisms directly in the statute and not reference the CPA at all, the Consumer Protection Act. So we'll just read through subsection C on line 12. It specifies that a person who sustains harm or injury as a result of debris left on a construction work site in violation of the best practices established pursuant to this section may sue and recover from the violator compensatory damages, reasonable attorney's fees and litigation costs, and punitive damages not exceeding 3 times an award of compensatory damages. So the treble damages, the attorney's fees, those are all under the CPA. So those would directly apply here, again, with no reference to the CPA. A couple of things. And this is going to get to the one topic that has come up a couple of times and definitely came up with Mr. Flynn's testimony. What is not covered here is an avenue other than litigation by a plaintiff to receive restitution. So under the Consumer Protection Act, the Attorney General has discretion to bring an action on behalf of the state if if he or she believes there's been a fraud or an unfair practice. And as part of that lawsuit or action, can also seek restitution on behalf of a consumer. The proposal you heard from FX Flynn was maybe there could be a mechanism that would get harmed individuals some advance payments prior to going through litigation, or something along those lines. It wasn't quite put that way. Mr. Flynn talked about the workers' compensation model. I think that model presents some difficulties. However, there are other models that you could look at. There are victims restitution special funds in Title 13. There's also a restitution fund for securities violations that do allow for, in some instances, advance payments. Of course, there would have to be a determination about whether a harmed individual is entitled to those advance payments. There's often a cap on the amount that they can receive. And there are also subrogation rights that usually attach to any of those payments. So I just wanted to kind of flesh that out a little bit. I'm not sure if you wanted to proceed with some kind of restitution model. There are other options. You could ask the PUC to open an investigation and assess damages, potentially restitution. I just wanted to really flag that that's something that's kind of been floated about, but not specifically talked about by the committee, and that there are options in that regard. I believe, so that is it. The bill would be effective on passage. So the PUC would get to work on the bulletin. There is an end date in terms of coming up for issuing that bulletin, and that's dated at the beginning of subsection B, September 1st, on or before September 1st of this year. Other than that, there's a suggested change to the title to better reflect what's in this draft. So that's an overview of that option. What would you like to, do you have questions? Would you like to hear from the PUC?
I think this is moved us forward a big step. Because we were kind of almost reinventing the wheel. So Senator Sirotkin, you have a question?
A comment. I hesitate to make it after seeing everybody nod their heads to your thing. I think it's probably our fault. We've created a monster here in terms of trying to identify a solution to probably a fairly isolated problem that could be replicated in 8 million different ways in our society, where somebody gets injured through the negligence of another person. I think all we really want to do is make sure that the
All attaching.
attaching entity is ultimately responsible if people below them don't have insurance or pay the bill. And all this other stuff is starting to deal with, I think, starts getting into judiciary's bailiwick. And we should just say that the attaching entity shall be responsible for the injury if people that in the chain are not produced.
I think what I heard the other day is that is what happens, and
I think that's what happens with mortgages.
yeah.
Just
And
assign the responsibility to the person with the deep pocket, and they take care of it to make sure the people below them have insurance. Otherwise, they're gonna pay the bill, and they have deep pockets, you
Yeah.
know.
I think, Maria, what you've done is take these things that sound like they're the common practice. I know every time I've typed a roofing kit, and there's been quite a few, the last line is clean and leave the premises as found. And it's very specific in the bid, if they will or will not remove certain materials that they're taking off, and who is responsible if they are, and who pays. And I think we heard from EC Fiber that that's standard, but insurance companies and lawyers are insurance companies and lawyers, and they look out for the best interest of their clients. So just for clarifying, I think what Maria is doing is taking,
I think she's doing what we asked her to do. But
yeah,
think it's
no, but
just
I think
more-
all she did is just ask the PUC to put out a formal bulletin of what is, at least by the reputable contractors, standard practice. So then there is formal notice. So there's now a formal policy, and if something goes wrong, then the injured party has the right to sue and up to triple, so they get the protections of the consumer fraudulent, they get additional protection. So I think that's what we're doing here. Okay, Senator Pearson.
Just a question for Maria. Your draft also takes us out of the unfair and deceptive act zone of statute, right?
It does, yes.
Which I sort of think is helpful. I guess the senator, first of all, my hat's off to Maria, because I feel like I didn't know what we were trying to say. And somehow you've put it on paper and I'm like, yes, this is what I was hoping for. So
That's
thank
good.
you. Senator Strachan, to me, you know, I actually do think we're not making a big change to the legal and insurance universe here, but it's a belts and suspenders thing, and we're making it clear about damages. And the difference, and I wonder what you think, these are actions that are happening because the companies and these utilities have right of way through private land all over, and we're getting into, with any luck, the next several years when thousands of miles of this stuff will be strung. So, and they have a right to be on private land. They don't have to ask and re-get that. They have the right today. So to me, there is a little, that's a little different than the common sort of, or I mean, it doesn't change common law, but it is a slightly different dynamic. And I guess I'm not convinced this changes a lot, but it does seem like it's certainly not going to hurt. It's not making it more complicated. It's kind of calling it out. So I'd like this. I'd also
Yeah.
before I get too enthusiastic, I'm hoping we'll hear from.
Well, yeah, that's what I want to hear from Carla and this Marinello. So, but we've got any more questions? Senator Bray.
Ms. Royal, so a bulletin, is this comparable to like rulemaking, has force of law? Can you put us into the great chain of being for rules, bulletins, guidance?
No, it's a great question. And, you know, I did receive, you know, one comment after the draft went out, was published from the PUC, that they're probably bulletin is, some agencies have the authority to issue bulletins. There's like the administrative bulletins on government contracts, on procurement procedures. DFR issues bulletins. They are, as the chair mentioned, kind of just a formal statement of policy and requirements. However, it's not, I don't think the term is defined anywhere in Vermont law. The PUC, I don't believe, ever issues bulletins. Probably the right word would be order, to issue an order. And the idea was not to be a rule, not to require all of the procedures of an APA rulemaking, which can take, you know, at least 7 or 8 months typically, but more of a formal considered statement that addresses these specific issues. And so you will hear from the PUC, but I have a feeling that specific term bulletin will, if it goes forward, will change, maybe to be a PUC order.
Thank you.
Okay, any other questions?
No.
Senator Saracen.
So Maria, just point me to where it's clear that the attaching entity is clearly liable for the work of their subcontractor that screws up.
So I would say that there's nothing in here that specifically says that what you had raised earlier about, one approach making the attaching entity, liable, and then, allow the harmed individual to sue that entity, recover damages, and then say the attaching entity can seek damages from its contractor subcontractors. That model is not represented here. And it doesn't specify really who is liable in any way. The closest it comes is in subsection B, line 12. The best practices and insurance requirements contained in the bulletin shall apply to attaching entities, contractors, and subcontractors as deemed appropriate by the commission. So you can be more prescriptive about how you want to apportion liability, or I left it a little bit open so that the PUC could come up with a model that makes sure there is coverage and protection for harmed individuals, but might not be so disruptive to the insurance industry and their standard way of doing business. And I'm not expert in that area, but that was part of why it's maybe a little bit not so prescriptive. But you can be prescriptive. You can put into statute, if, for example, if you knew that you wanted every contract to have a minimum of $1 million of coverage, you can do that. Some of those things, I wasn't sure how you wanted to handle them, which is in part why I have it done by the PUC, by the order, but with some parameters set. So anyway.
I think the thing that would concern me is, what if the middleman is the one with the deep pockets? You've got some small local CUD with no money. They hire a major company that then hires a subcontractor to go out and do the work, which may be what EC Fiber is. I'm afraid we'll be back here in 2 years with somebody who was denied the protection because we said it had to be the pole operators. So, Senator Hardy.
So I do want to hear from Kyle.
Yes,
he might
we are going
answer
to
some
hear
of
from
my questions, but I think ultimately my goal in introducing the bill in the first place and getting us in this quagmire, my apologies, was to try to prevent something like this from happening again. And, obviously you can never prevent accidents, et cetera, totally, but that there were standards and a clear obligation and worksite cleanup, et cetera, et cetera. And I think that's captured in this draft really well. It's sort of like the way that Senate Education handled the school mascot thing. They set up had the Agency of Education do a model policy that school districts are going to now have to follow. And that's sort of what it seems like this might be. And that's why I want to hear from Kyle to see what the actual force of this kind of thing is. Like, because you're right. I think you said it. There are going to be hundreds of these Chris, out in the field.
There may not be any. I mean, we're hopefully, but.
Well, hundreds of people out there stringing fiber, and we want to make sure that they're following best practices. And this seems to be like a best practices announcement.
Okay, I've got Senator Brock and then Senator Sorokin.
Well, in the kind of situation that we're talking about here, we're often talking about one where one subcontractor or somewhere in the chain of contractors doing this work creates a problem and someone is injured. Would generally something like joint and several liability apply so that everybody who's involved is involved for the entire loss, regardless? And then it gets sorted out. It gets sorted out in court depending on who has insurance and arguments between the various people in the chain of command.
I
or
think
the chain of
part of
involvement.
what we wanted to do also was to make sure the process was as quick as possible, so these folks aren't sitting out there 2 years later with a huge fee bill and everybody else is still in court.
Yeah, it's just that what you don't want to do, you don't want to create a situation, as we talked about, where it simply goes up to the CUD who doesn't have anything, and that's the person who's theoretically responsible. Everybody's responsible
Yeah.
in this chain of contractors of involvement. And that's the thing that I just want to make sure we don't get lost.
No. Senator
So I just want to respond to your comment. I lost that in these legal arguments. That's a whole different element of the bill. That's good. You know, just, I don't know how, maybe this is the best way to get best practices out there, because with this bill, it's possible that someone could get sued even if someone wasn't injured. You know, clean up your mess, you know, so that's a lot. But we really got bogged down in how we're gonna make this family whole. And the marketplace, as Senator Brock says, takes care of that itself. And you just, it's sort of like strict liability or joint and several liability. You say that the person who's more responsible, my brother has a window replacement business. He's got subcontractors and subcontractors, and the whole building wants to sue that one subcontractor, but he doesn't have any money. And they go to the next person, they go to the next person because it's an injury. But if you say in a law in this context that they're all liable, or ultimately that person at the top is liable, that's the way it started out of the judiciary. But then that group, as Christine said, this is not an issue. We all have insurance. We're all going to have insurance. The problem is what they didn't have is they didn't have notice of when the insurance got dropped by the person down below. Otherwise, the insurance companies work it out who's the primary person. But if that insurance company doesn't pay, then you can go to the next person. So
Okay. Let's hear from Kyle. We have no other questions. Okay, Mr. Landis Marinello, the floor is yours. We've just dumped a whole lot of stuff in the PUC's lap.
Yes,
What
thank
do you
you.
know about that?
So I'm Kyle Landis Marinello, General Counsel at the Public Utility Commission. Thank you for having me in here. And you know, we were part of the discussions in Senate Judiciary, and we were okay with the version that came out from Senate Judiciary and are still okay with that version. I do understand their concerns the Attorney General's office has raised that Maria mentioned about the Consumer Protection Act. But just to give a little background of why I think there was a look towards going to the Consumer Protection Act, I think it's because our agency is not set up to actually move money from one private party to another party that's been harmed. That's not something we do. The Public Utility Commission is primarily an economic regulator of public utilities. Because utilities have a monopoly, we need to always be looking at what they're charging. It's only certain public utilities. Broadband is generally regulated at the federal level, and they come into our ambit in certain circumstances, like here, where they're attaching to utility infrastructure that Vermont utilities own. But when we look at it again, we're focused more on the economic aspect of it. And so this is all a long way to say that the things that are being put on our lap were already different from what we normally look at. And this latest version goes even further in that now we're kind of being tasked with coming up with insurance requirements for these entities. And that's really not within our wheelhouse at all. And I appreciate it says in consultation with the Department of Financial Regulation, because they do insurance. And so we can do this if that's what the committee wants. I appreciate Maria recognizing that a bulletin isn't how we operate. I'm not aware of any bulletins we've issued. And so the usual language in something like this would be to allow us to do something by rule or order. As a practical matter, we would do it by rule and by order, because as Maria mentioned, the rulemaking process is lengthy and has a lot of requirements and is very resource intensive for a small agency like ours. But I do want to be clear, it makes me a little nervous to have us tasked with writing requirements about cleaning up sites, which is more a agency of natural resources specialty, requirements about insurance, which is more a Department of Financial Regulation specialty. And then those requirements have the force and effect of law as I read this statute, and entities can go to court and sue over it. And so if we do this process, I just worry we could have a lot of entities come in and want to be part of the proceeding, want to challenge the order that we come out with at the end and go up to the Vermont Supreme Court and say, you can't make us have this amount of insurance, you can't make us do this level of cleanup. I don't know what standard the Vermont Supreme Court would be applying to see if we got it right. We certainly wouldn't get any deference, I don't think, because these aren't really areas within our expertise. Although if we're being asked by the legislature to do it, then maybe that does accord some deference. But I do think if we were, particularly the insurance requirements, if we were going down that road, I think the Department of Financial Regulation is better suited. They do have a process for having bulletins. We have a good relationship with them. I have reached out just today to their general counsel to talk about this latest version, and he did want me to convey they would like to be brought in to talk to the committee about this, and I think that does make sense if we were going down the road of moving this towards the Department of Financial Regulation doing it. So ultimately, we're okay with the version that came out of Senate Judiciary. We'd be fine with adding something to that in the statute puts a requirement maybe on all attaching entities and all their subcontractors to have adequate levels of insurance at all times. I think a sentence like that can easily be put in, but ultimately, I think the committee has to decide kind of who's going to adjudicate these matters when they come up. And the Senate Judiciary bill has it going through the Consumer Protection Act with those options. This version, as I read it, has it going to civil court. But I would ask that the committee clarify that, because I don't want someone to actually read this bill as having us adjudicate this type of matter, because that's really outside our expertise.
Senator Gray.
Mr. Landis Marinello, so I wanted to follow up. So we would need to move away from bulletin to an order. The other question I had is about enforceability. So if it's one thing to give notice, but then it's another to use police powers to enforce. So is that something you already do in some areas? I'm not familiar with the PUC enforcing. And so who would actually enforce and then carry forward, for instance, into a court proceeding?
So we can impose penalties on entities that violate certain provisions of Title 30 and that violate commission orders. That docket tends to be certificate of public good holders. Those are the primary violations we see, as someone will get permission to build a 500 kW solar project, and there are requirements on how they build it, and then they end up clearing twice the amount of trees they said they were going to clear. It comes to our attention, we have an enforcement proceeding and impose a penalty on that entity. But there are very specific restrictions on that. It has to be an entity that has a relationship with us, which is not necessarily going to be the case for subcontractors like we're looking at here. And we impose penalties that then get sent to the general fund. We can't provide restitution to a harmed entity. We can do enforcement, but I do want to make clear our enforcement is really focused on the entities that have certificates of public good, which here EC Fiber does have a certificate of public good. Their subcontractors do not. Other broadband providers who are stringing fiber optic cable may get permission from us to do that through an affidavit process. And I think we would have authority if they violated our rule or a statutory provision to bring an action against them. But it's not clear to me where subcontractors stand. I think we're set up really to deal with the person at the top there who has the obligation.
So the penalty is for violating the order, for instance, but it's not necessarily proportional to the damage that someone suffered, like in the case we're talking about, right?
Yes, there are specific limits on the amount of that we can require as a penalty. There are factors we have to look at. Anytime we impose a penalty, someone looks at how we treated similar incidents before, and so we can be subject to challenge if we impose a penalty that an entity thinks is higher than what we've done historically. And so and you could have a situation where the amount of the harm is actually significantly greater than the statutory cap we have for one incident. In fact, I think that probably would be the case, as I understand the amount of damage that was done here. I believe our statutory cap for a single incident is $85,000.
Okay, thank you.
Okay, I have a suggestion. We've got the PUC because this incident happened to somebody that was stringing poles. But there are other instances. There was somebody that went down an elevator shaft while working on a roof and died. There were, that these kinds of damages happen outside, and we're really talking about insurance and how the insurance, and I'm not clear that it isn't already clear that if your sub doesn't have insurance, you are, and it works its way up the line. That's what's going on in this instant. I don't know about the goats. Goats eat anything. But what we're, I think, most concerned about is that these people did not get, there is no quick remedy for them, and we're trying to find a quick remedy. I'm watching the clock and I'm watching the clouds. We have an insurance housekeeping bill. I believe it has already come over. That would be a possible vehicle. And that would give us some time to work this through in terms of what is the norm in these kinds of subcontractor. And it would probably be the insurance, DFR. I know there's tension about who regulates between DFR and the Attorney General's office, but I like the solution Maria came up with, is putting the ability to sue without having to go to court and say, well, it really isn't consumer fraud. I never talked to these people. How'd I defraud them? But that would be a way, rather.
I'm fine with that. I work with Maria to try to come up with language that we could insert with that in that bill, maybe?
Well, I'm thinking Maria does our energy, telecom. This might be something we'd work on with the insurance people.
Right, well.
And
so-
Maria again.
I'm sorry, Maria.
I was gonna say, I do the insurance bill also, so I'm
You
here.
are.
Oh, you're doing insurance, that's right, all right, so you can talk, but Maria, do you think probably insurance regulation is more the, rather than utility regulation is more where we want to go?
I don't really know, to be honest with you. I think it'd be great to hear from DFR a little bit more specifically, get their thoughts on it.
Because I think we're trying to solve two problems. There's the insurance problem, and then there's the problem that was my original motivation, which I tried to state earlier about best practices for worksite cleanup for utility projects.
That's probably another department.
Yeah, and that might be, I mean, maybe we ask Public Service Department or the new board, Christine's operation, to come up with.
Christine's operation might be
with
with
rules
rules
or
to
something.
say, these are the standards, yeah, and we could talk to Christine's operate, you know, we
it's sort
can
of
have
the-
Christine in when we get back.
Just bear in mind, this is the problem, is a pole attachment problem, and that goes beyond simply the internet. There are other
It's
pole
true.
attachments that are
Yes,
going on
you're right.
that create the same problem. And it seems to me that it'd be useful to solve the problem at once.
Right, so maybe it's the PS, the Public Service Department.
I would
that
start there as a
Yeah, I
recommendation.
mean,
Okay,
So, but the point is, we maybe have other bills that.
we have a bill with insurance in the title now.
yeah, we can do the insurance part there, and then we can do the other part there.
No, we can stick it all on as long as someone doesn't object.
Yeah, it probably is germane because, you know, it's the underlying cause that would have insurance kick in, and I would think is related.
It would be just a DFR,
Okay,
but they gave us the sandbox and a few other non-controversial things in their TV bills. So, you know, it's fair.
So
Send us
in
around.
this world of broadband development, I was wondering if other states have maybe faced this question and if there are any other laws that deal with this that we could check on and see if how they've approached it in other states. I'd also still be interested to know how the big boys, girls approach Comcast. Maybe they're,
Yeah, we thought we had someone from Comcast and they couldn't get in the other day.
yeah, and then just say, how do you deal with this? Because I'm sure, I mean, the way this, at least on the injury side, the way it works, if someone gets hurt, they sue everybody. And then the big boys know how to protect themselves from not having insurance lap on their subcontractors, but somebody who's up and coming may not, and then they've got to fight it out. But the Comcast of the world have insurance in case they ever
Oh, yeah.
get stuck, and so maybe they can shed some light on it.
Okay, yeah, we will. It won't be next week, because next week, well, no, next week, I'm thinking we're gonna be weighing our way through.
Right.
For some reason, we got the peer counseling bill.
oh, we did?
Yeah, and I'm still not clear why we got it. Except that it
Oh,
had-
there is a fee in it.
That's why.
There's I think for those
if
new
that's all we've
centers.
got to do is a
I'm pretty
fee,
sure. I
we
think
can
there's-
knock that out of here in 10 minutes. Okay, because I'm saying, well, it was Medicaid eligible.
And the peer
That's
respite
it.
council, the certification, there must be a fee.
Be in there. Okay, we'll work on that one then. All right, so we will continue to work on this. I think we all know where we want to go. It's just finding the appropriate home and finding the appropriate wording. I think it is standard practice from what I've heard that everybody has insurance. The question is what happens with, I think it was Irv, you got a rotten apple.
Yeah,
He lets his insurance lapse 2 days before the job ended. But then you've got the attorney saying, well, who knows when the cows ate the wire? And that's the way it is. Okay, so we are gonna go off this one. Since we think we found a way to
so Maria, I can chat with you about
deal
it.
with it in the future.
Okay, great.
Thank you,
Okay.
Maria.
Thank you.
Thank you, Maria. And now we are going back to our favorite.
Thanks, Kyle.
Thank you.
Let's see. Yes. All right. So we are looking for Ellen and for Ken Jones. And I think we have all gotten copies, it's posted, of the, cleaning all this stuff up. Okay, this is 161. We've had them printed, here you go.
What is this one?
Right.
Oh, another
This is
fun.
this is our last bill. Here is the most recent copy. And we've all been sent online, and I didn't have it printed because it's very long. We required ACCD and Fish and Wildlife or Parks and Recreation to do a study on if we close that plant down, what were the alternatives? Or what was the economic impact? What was the alternative for the workers? And I read it last night. It is, I think it's been emailed to us like 3 times. I think we got a direct one, we got one from somebody else, and Faith forwarded one, and it is online, and I'm waiting for Ken Jones.
This is the bills introduced, is that what we're supposed to have?
We have not made any changes to it at this point. We have the timeline from Dylan. And I'm looking for my copy of that. And so Ellen, I'm assuming you don't have anything for us at the moment. So committee meeting,
Senator Cummings, this is Faith. Ken Jones is about to join us.
Ken Jones is going to join us. Okay. So we will hear from them since we asked them to do this for us when we discussed this 2 years ago.
We discussed it earlier this year.
Yeah, but we asked Forest and Parks when we did the first extension. The countermanding concern in all of this has been the economic impact.
You're correct.
Yeah.
What was one of the interesting things that happened in the intervening year was the loss of the plant in New Hampshire that used to take 200 truckloads a day. It's no longer in operation, and looks another plant that was smaller, bigger than Reiki, smaller, that also closed. So a very small slice of a very large producer farm.
Okay, so Ken is about to join us, but this is it.
Is this?
And we also, I assume, have been getting emails from Annette Smith, who has sent us.
Yeah, we haven't got that. We've got, could I just ask Ellen, I had forwarded what Dylan had proposed as an alternative to Ellen, not because I was dying to offer it as an amendment, but just so we would have it if we meant to do that. Do you have that language, Ellen?
I saw the language. I have not turned it into an amendment, no.
Okay. All
All
right.
It's on our website though.
Yeah,
Dylan's
but
proposal.
it's in Dylan's,
Right.
you know.
Dylan's is on our website.
Okay. Well, that got lost in translation then.
So look, Ken is here. Let's let Ken go through and then we'll see what we can come up with. I may just have to turn the report. Faith, I'm gonna have to shut you off for a minute so I can find reports.
Well, the
The
report
report is on our webpage.
I know, but I can either do
I understand.
on Zoom or I can do. I'm gonna have to bring my laptop in here, I think. Okay, so Ken, why don't you walk us through the report that we asked you to do, and we'll see where it goes.
Okay, so yeah, I don't know if I have to do for the record, I'm Ken Jones, Economic Research Analyst at the Agency of Commerce and Community Development. And so, yes, we were asked, I think it was last year, piece of legislation for us to do a contingency study on the closure of Rygate. So I want to be clear that that's how we approach this. It's how we also did our public meeting. This was not an evaluation of the plant as to whether it's a good thing or not, but if it closes, what can we do? And I broke it into 3 parts. And as the result of public hearing, I added a half a part. The 3 parts is A, the replacement of the electricity that's generated at Rygate. B, the use of an alternative use of the wood that goes into the plant. And third, the other economic activity that takes place as the result of the facility. So, and the half of one, I was reminded at the hearing, is that they generate a great deal of ash, and that ash has economic value. So that's a third, the third and a half topic. Okay, so in terms of electricity, I'm not gonna, our public service department, this is their realm. And so I chatted with them, and this plant represents about 3% of the total electricity used in the state, but about 7% of the electricity generated in the state, because we get such a significant amount from outside of the state. And that's even that 7%, though, the way the public service department considers it is that it is all replacement electricity that the utilities can get from the ISO New England market. So the contingency, if this plant closes, the starting point is just to consider that the electric utilities will go out and get their electricity from the market, in some cases short-term, but over time, the longer-term contracts. And the price of that electricity is actually lower than the price that's paid at the Rygate plant. And that is a reason why there is not a unanimous belief that the plant should be continued, because you can get electricity cheaper. So contingency for the replacement of electricity is to get it from the market. The wood part, that's the largest part of this report. And that is the wood that's being used at the Rygate plant, you probably know is, and I use the term low grade, and I apologize, I don't mean to offend anyone, because I did offend some people in the public hearing. There's no such thing as a low grade tree, but this is wood from an economic value on a per ton basis that is worth less than wood that's used, at the high end for veneer, for dimensional lumber, those high end. It is a byproduct that loggers have when they go into the woods, and it generates, or the plant uses about 130,000 tons of this chipped up wood that doesn't have a market in those higher end fields. So the question is there something else that could be done with those wood chips? Those wood chips that include. Oh yeah, I'm sorry.
No,
please.
This is the joys
Of hybrid. Hi, Ken.
Hi.
You're saying 130,000 tons of wood chips are used. It's my understanding that some portion of that doesn't come from Vermont, but comes from New Hampshire, if not further. And I wonder, are you distinguishing there? Is the 130 just what is actually harvested in Vermont?
Yes. Yeah, it's 240,000 total, 130 Vermont. Actually, a surprising amount comes from Massachusetts. I was surprised. But yeah, that's 130,000 Vermont wood chips, 240,000 total.
Thank you, sorry, I must have missed that. And then a further complication, some of the harvesting in and out of state probably is done by Vermonters and vice versa. So in terms of a jobs impact, were you able to dig into that, or do we just have to make some generalizations?
Yeah, I didn't. So the report just talks about the number of workers that the chipped wood represents. And I think it's 35 workers kind of on a real regular basis, and another 15 or 20 that are sporadic, that when they have a higher demand than being met. So it's, but I did not do the analysis of the impact of that work. In other words, what their wages are and the secondary impact, but rather I just looked at the sort of contingency, which is, if that wood chip demand is reduced, is there an obvious set of activities that can replace that wood chip use?
Thank you.
And this is where, in part, I rely on the work done in Maine, because Vermont is not alone. Maine has given a great deal of effort to trying to explore other markets for both high-end and low-end wood. And they've done a lot of work. They've identified a lot of possibilities, but none of those possibilities at this point have an established market. And in general, and I don't know how much you folks have been bombarded with wood stuff, but in general, if you think about it, wood is kind of like petroleum. In other words, it can be a feedstock for making things, for making other chemicals. And indeed, it can be a replacement for petroleum, and that would be a great thing. But the markets for those have not yet formalized. And so we can't say today that we can take 130,000 tons of wood chip and turn it into some of these fascinating products that may be possible in the future. So that's a big topic that is being explored, and it's not ready for prime time. The other sort of direction to go is to consider, the obvious, is there another wood chip consuming power plant that might be more efficient, more economically efficient? And the answer right now is answered by the fact that most of the wood-fired power plants are closing in the northern New England area. So there isn't an obvious, no one's building new ones. There have been a couple of renovations in New Hampshire, but they tend to be even larger than the scale of Reigate. And they were still heavily subsidized, one at a paper mill in Berlin, and another at an old coal-fired plant in the Portsmouth area. So that obvious, can we just build a new wood-fired power plant? Right now, the answer is no. But it then takes you to the somewhat related, what about wood chips, or what about wood pellet plants? And you may or not know the history. We've been exploring additional wood pellet manufacturing, and it is a difficult market in which to build a new wood pellet plant. And in fact, we lost when we had one in North Springfield, and it actually closed about 3 years ago. And the wood isn't exactly the same. You need a higher quality wood than is used in the Reigate plant. In other words, you can't use the tops and the sticks and twigs and leaves and bark. That tends to be debarked wood that is used in the manufacturing of virgin pellets, which is what our mill in Clarendon, they actually use virgin pine. I shouldn't say virgin. They use pine logs, debark them, and they make, by burning them right now, they make very, very good wood chips. But the point is that market is not a exact one-to-one relationship to the use of wood chips for a power plant. So,
Senator Bray has a question.
yes.
Mr. Jones, good to see you. When you looked for alternate products to get involved in, did you look at things like, I don't know if it's oriented strand board or laminated, the new sort of structural wood products that I think were being explored or developed down in Brattleboro area?
Yeah, cross-laminated timber is the hottest one, and that market is going to need a higher grade log. So that much closer to the dimensional lumber market. And so it actually, I'll say, argues it is a different pursuit. If we're gonna go to cross-laminated timber, we may increase logging activity, but that may actually increase the amount of lower grade wood that needs to be managed. It's not, the types of trees that go into a chipping facility, go into a chipper, are not the same wood type that would be used for a cross-laminated timber. And I don't know the Vermont market for, the fiber board, those other boards that have little chips of wood in them. That doesn't seem, I don't know as much about that market. Doesn't seem like anyone's saying that is a market that is ripe for expansion. I say that, the new one that people talk about with enthusiasm is cross-laminated timber, but you need a higher quality timber product to feed into that. And I guess I'd ask you, you've got folks from the Forest and Parks that understand the wood market, that they can answer those specific questions.
Thank you.
Okay, so the short answer is there is no immediate viable market for this lower value wood product that Rygate consumes.
You have summarized it correctly, Senator.
Okay, so
it takes me, if I can, that takes me then to the third piece, is that mill is like any other sort of economic activity from an economic development perspective. And the mill itself hires 20 people and has additional about $4 million of non-forest wood activity. And so if the plant closes, that's also another piece that needs to be substituted. And so, and I'll say an obvious first thing to look at, is there something else to do with that mill that would allow for economic activity? And again, unfortunately, the answer is no. And again, the evidence there is that New Hampshire has lost 6 of its mills that are very similar to Rygate in the last 5 years. And in no case are any of those mills being repurposed to any economic activity that I am aware of. One of them has reopened as a wood-fired power plant. So, that's kind of similar to Rygate. If they can continue to make the investments to improve its efficiency, then that's still available. But that, I don't know if that would be considered a contingency or not. So those are the 3 categories. And then again, the half is that the ash does represent a few tens of thousands of dollars worth of activity. It goes to farmers, but and it's a good product. It used to be one of Vermont's greatest exports back in the early 19th century. But it is only tens of thousands of dollars, and it largely can, from a farmer perspective, can be replaced by significant amount. Lime is largely the chemical that ash replaces, and then a little bit of fertilizer. There's a little bit of nutrient in ash, but a significant amount of that soil adjustment. So, but yeah, to go back in terms of that third one, we at the Agency of Commerce look at this Rygate plant as we would look to any sort of business closure. Are there anything other than the specific reuse of the plant that we can do to foster economic activity in the Rygate area. And that's how we would look at it, much as we looked at the closure of Vermont Yankee, which was of course a much larger economic activity. But the sort of replacements for that, we put a little bit of extra effort into saying, okay, what can we do in Windham County? Well, that would be the same sort of contingency for the closure of a Rygate plant is, okay, 20 jobs, a little less than $2 million annual salaries. Is there something we can do to support some activity there? Can we funnel a little bit of extra resource into the Rygate area to replace that economic activity? But again, nothing specific about the closure of Rygate itself that leads to an obvious, oh, there is an economic development opportunity.
Okay. Ken, last year, and I don't know where it came from, we were told that 30 to 32 small logging operations would close because being able to dispose of this lower value wood was their profit margin. Did you come across anything like that?
Only that, right? That those arguments that are out there, and I understand those arguments, that to go into a woodlot, if you can only take the higher value trees, it isn't worth it. And therefore, those folks that trying to get the higher value trees would have to increase their prices on those in order to continue to log. And so they need just to have that, $20 to $30 a ton value on the low stuff to rationalize their entering into a woodlot for extracting the higher grade product.
Okay. Committee, any questions for Mr. Jones? All right, it is 3 o'clock on Friday, on the last day of crossover. What do we want to do with this? It has always been a balance against the less than perfectly efficient electricity with the economic activity. And if any of you have not driven through Rygate, it's right down there in the Connecticut River. It's pretty just.
Can I ask Ken that
Yeah.
question? Did you look at other economic development alternatives beyond forestry and the Rygate for the area more broadly?
Yeah, no more so than we do 24/7. In other words, the role of the Department of Economic Development is to consider where are there economic development activities that the state can participate in. So that's a question we ask all the time, everywhere. And so when we ask specifically about Rygate, nothing arises. So it's the same as the rest of Vermont. The extent to which we wish to improve the economic activities in a place is going to continue. And there's nothing at Rygate that makes it any different, unfortunately.
Okay, because it seems like the report is based on the premise of if we're not going to use the trees for this purpose, we have to use the trees for this other purpose, and there's not really another purpose to be had, rather than a broader economic development analysis. But if that's what you did, that's fine. I'm just wondering if you came up with anything else.
Well, I don't know I know during the public hearings, and certainly we've heard this before, is that forestry activity. If you don't do that forestry activity, is there something else you can do in the forest? And certainly there's a lot of discussion about the ecological condition of the forest with and without forestry. Can you capitalize on that economically? We don't know any examples where that's the case. We have literally millions of acres of forest in Vermont, and whether there's a difference in how you use it non-forestry, if it's logged or versus it's not logged, we don't know of those opportunities. So at least from that perspective of an unlogged woodlot, does that open up a new opportunity for another activity? We don't know of anything there. Again, we have millions of acres of forests in Vermont. And
But we did a study on that a couple of years ago. You should ask the Commissioner of Forest Parks and Rec.
All right, Senator Brett.
Well, I think, one challenge would be is if we say, for instance, that, that we need people in the broadband, we need people in all sorts of jobs, but my experience is that people who work in the woods love working in the woods, and it's not, they're really, it's not like just a transition to, I was a carpenter and I'm an electrician, that might be a little closer. Usually it's like you're out in the woods all the time, and there's no other place that's really like that. So I could see it'd be hard to get someone who's logging, surveying, et cetera, all that stuff, to say, oh, I'm gonna take a job in a completely different industry.
Drive to Randolph and get in a truck and string cable. It's also part of the traditional Vermont way of life, and up in the kingdom, that's a pretty strong force, and I think that's what bothers me as much as anything. But we are where we are, and it's just a question, I think, of when we pull the plug.
I know that we're not, so the question I have on this is, because this is a bill in are we needing to get this out as a original?
Yes, this is our last bill that is ours. We have taken this up at least 3 times and run into a stone wall and taken a break, and we're back at the stone wall.
We sent it to the floor, and then under Rule 31, to refer back to us. I don't know.
No. It's, we're in.
Good try. Infinite loop.
Yes. No, it is not. We are sending this probably to House Energy and Technology if we get it out.
They'd like it.
So.
So,
Do you have something you'd like to share with the committee, Senator?
I was waiting. Try to make a simple chart and right off the 2 circles are supposedly of equal size. And this is the amount of money, the subsidy that is being paid by Vermont ratepayers. It's only being charted there to compare it to where the subsidy actually goes. And the 100 goes for 110,000 tons of flesh products for New Hampshire folks, and it goes to 130,000 tons for Vermont folks. So you're purchasing this power more expensively than we would ever pay for this power in order to subsidize this many Vermonters and that many New Hampshire folks.
That is.
And so that's what the numbers are. The plant owners came in and said they wanted some time to run an experiment to get to increase their efficiency by 50%, but they haven't given us. I don't understand the definition of what 50% of what. And I say to the committee that if they can be 50% more efficient in their production of electricity, they should be able to sell it at market rates and don't need a subsidy. And that's a supposition that I'm not qualified to make. But I think that's a reasonable thing to say. And finally, it's in here because we deal with electricity rates and how they work in Vermont for Vermont ratepayers. And our discussion has tended to slide from electricity Vermont ratepayers into economic development, which is in the community. That's a and I said a few weeks ago, if if they can come up with a study that we can understand how to be more efficient, in order to achieve a good deal, or reasonable deal, or equal deal for Vermont ratepayers, I'm all for that, and I would give them the time to do it. And perhaps they've made their case.
I think in the past, if I've read the things, they've talked about not making the electricity cheaper. They've talked about using the heat, all right? And there is nothing there to pump the heat to. I think we heard that Burlington hasn't been able to pump its heat anywhere, and it's a lot closer. So we have this. And I really don't see state lines when I'm talking about people's livelihoods. Hungry children are hungry children. The question is, are we going to go through with this? And Senator Sorokin, Senator Pearson, Senator.
You're up first.
I think Senator Gray's first.
Well, I would just follow up a little bit on what Senator McDonald alluded to. As best I know, the efficiency increase has nothing to do with generating power or more electricity. So I'm willing to sort of run the experiment because I do think it's a fragile economy, and I can't imagine many of those people transition to other work. I mean, they certainly could, but it's a whole culture and way of living, making a living, et cetera, that will suffer. So I'm sympathetic there. I don't like the language in the bill itself, this claim of overall efficiency increase by 50%, because it's not defined, and frankly, I feel like it's a little bit of salesmanship, that it's largely irrelevant to why we would do this. Because usually we would say the efficiency of the generating station, and it's going to stay the same. Yeah, but to put this 50% in, I would hate to be presenting this bill on the floor, claiming a gain of 50% efficiency when it's really an ancillary activity, not connected to the operation of the plant.
Right, it isn't.
So if that's the part that doesn't pass a straight face test to me, otherwise I'm willing to support moving.
Okay, we can take that out. Or we can find another way to word it. I've got Senator Pearson, then Sorokin. Is that okay?
So I continue to be torn on this one, but my question is for Ellen. Ellen, if we don't do anything, the plant operates for another till sometime in 2024, right? Well,
yes, November 1, 2024.
okay, so they get another year and a half, and they can continue to operate. We should say more appropriately, they continue to be subsidized by ratepayers. If and there's this bind that I am somewhat sympathetic to, that the plants, we asked them last year when we gave them a few more years to find a co-locator, and it was, I agree, we were imprecise maybe about our efficiency language, but I think at some level, the hope was if you added another, you wouldn't make the electricity more efficient, but you would get a double use out of that burned wood. But what are we, 2022? So if they came back to us, and this is trying to say, like, give us a chance at proving that case and getting it a contract, then, I'm somewhat sympathetic. We say, find a co-locator. They're saying, well, we can't find a co-locator that will make an investment and then make the investment and then learn that we've been closed down. So this is, sometimes we've called it the chicken and the egg thing. But I guess what I'm wondering is, if I'm the plant and I'm not getting very far with this legislation, next year they come in and they say, okay, we have a co-locator, we have an MOU, we have not a contract, not an investment, but we have more than a sketch here, which is frankly more than we've had today. Then we have something a little more real to talk about. Last year we were talking about shrimp, then we're talking about biochar, then people tell us it's a fiction about biochar. You know, it's hard to know what you're kind of answering. And I guess I'm wondering, there's been a talk of, let's just give them an additional year and don't do anything complicated. Maybe that makes sense. Maybe we don't even need to do that, and they would, you know, make a better case when they come back next year, presuming they could get more meat on the bone. I don't know. So I'm not offering anything concrete. I'm just tossing out some ideas.
I think what they've been saying is, we can't get anybody to talk to us unless they guarantee. And I'm listening to Dylan. I think what he's trying to say is, look, give us an extra year, which is probably neither here nor there. But if we get somebody and it is up and it is running, then you have to guarantee that you won't, you know, that you'll go back. The revenue will be caught, and so they may get a less favorable thing. But they're saying they'll have it built in 4 years, I think. If they don't,
They're
then
saying
they-
contract, under contract.
Yeah, but they need, before the guy's gonna put a shovel in the ground, he needs a guarantee from us that we won't shut them down. And that, I think, is the hard part. And we could tell them, just let this ride, tell them to come back to us with a solid proposal, you know, with the understanding that if this is solid, because, yeah, it's been all over the place, that if you've got a solid proposal, bring it to us, and if it's good to go, then we'll give you the 10 years.
So it's very difficult to find a future legislature.
Yeah, it is.
I think Michael had something.
Michael, yeah.
I'm kind of confused, but going back to some of Ray's comment, I thought I understood this when they said they were gonna come back and show that where it was gonna be reviewed and there was gonna be a 50% of something. I guess I didn't understand what the 50% of what was. I thought it was gonna be something like that 50% could eventually plow back so that the rates would be more market rates. But now I'm hearing that it's not necessarily that that's being measured, and it's not maybe happening for 6 years down the road.
I don't know about 6 years, but you're right about the rate.
Be down the road. Yeah, they're saying once we are using the heat, we will be making income. We're gonna sell the heat
Right, so we don't have
to,
to hit the ratepayers for that.
right,
extra income.
right, that the PUC will do a new hearing and set new rates once this thing is up and running. And I think they're asking.
They're not guaranteed 6 years, they're only up until the time, they only guaranteed 6 years if they need those 6 years.
Well, where is my copy of the charter?
Madam Chair, if they think
Yes.
they were to come back for something that eliminated the subsidy and was selling at market rates, give them the 10-year thing, that's
Yeah, there's a
So
whole
what we-
time
that's
when
the
they come
if,
back.
yeah.
Where is my?
written the condition
How many
for
we
it.
have?
No, but we're dealing more than just the bill was introduced, just having to get modifications by Dylan and this 50% thing. Just that confuses me. What is that? You know that it's now going to be decided by the Public Service Department versus the PUC, but what are we measuring?
Okay,
50%
let
of what?
me see if I can
It's not defined.
find.
I think what they're saying is, what was waste heat, you take the work value of that energy.
Yes,
And now you say, okay, with this much input fuel, and now that waste heat actually becomes work heat to do something else. you add up the value of the something else and the electricity generated, and now you say, well, we did 50% better compared to what we put in because we got the electric value out and we got the other work value out by whatever task that it was applied to.
Right, but when do the ratepayers benefit from that 50% addition?
I'd say they don't unless that other activity creates a revenue stream that then allows them to go to a lower.
So it's more an environmental thing than a
Yeah.
cost amount.
But also, I remember the PUC saying that they don't generally take into consideration a side gig in their creation of rates. Like, that's not a thing they've ever done. So, for me, the thing that is just, if I may, Madam Chair.
Yes,
Okay.
I'm looking for the,
Okay. The thing that gets me caught is that this is environmentally not a good plant, you know, the emissions and all of that. So if we're concerned about carbon emissions and doing the right thing by our climate, this doesn't seem like a good choice. It's more expensive for our ratepayers. And so if we're concerned about affordability issues and consumer protection, then this doesn't seem like a good choice. I hear Senator Bray on the argument that the people who have jobs associated with the plant indirectly as foresters, that that's a category of workers that may be hard to find different amenable jobs for. But I think there are a lot of sort of special employment that people love what they're doing and they don't want to do something different, or their skills aren't translatable or something like that. So I haven't really heard a good argument for why we should keep doing this, because it seems like since the very beginning of this plant, they've been trying to figure out what to do with the waste heat. They've been trying to solve this problem. And it's been 30 or 40 years or something like that, and they haven't done it. So I feel like if we come up with some scheme, whoever's sitting around this table in 5 or 6 years is going to have to keep doing this and just.
Is this a mini Yankee? I mean, could we take all the extra subsidy, put it into a fund and help the workers?
Well, that's what the owner has, a sort of a buyout insurance plan on the whole.
Well, they have a decommissioning fund, but that's for.
Yeah, but that's for the owners of the plant. I mean, I don't know what the right, I don't feel super strongly about this, but I just haven't found enough reasons to do anything but just say, do it, if you can't economically make it work, then that's on you. Because that's what we do with almost every business. Like, they just have to make it work or go out of business. Well, I mean, fair, but I think that,
And that workforce has also had opportunity after opportunity shut down in the last decade. I mean, the paper plants used to take, up in Maine, used to take all that scrap wood. There were several other wood fire plants in the region that used to take it, and it's just been trimmed after trimmed after trimmed. That is, it's not to say you're wrong at all, but it is a contributing factor to the dilemma.
okay, so if we do nothing, they still have their extension that we gave them. They could come back and say, look, we've got somebody ready to, that's interested, it's viable, this is what it is, but an actual proposal, which I think is what we told them 2 years ago. And that if you do that, but that can be, it's contingent on our giving them an extension, at which point we will have something to give them an extension on, is that?
We gave them an extension last year. So
Yeah.
if we do nothing, they still have had the extension.
They have until, I think it's 2024, January 1st, 2024,
November 1st.
November 1st, okay.
Why don't we give them an extra year?
That's what I'm going to do.
Okay, an extra year? Yes.
One of the alternatives is to say, you've got you've got the time, if you can sell it at market rates, all the rest of this stuff kind of goes away. Getting rid of the subsidy that is, once the subsidy is gone, it becomes clear. And a year ago, the last time we discussed this at length, the New Hampshire plants have closed down. It's a different economic situation. What has happened this year in the last month is, I was driving into town and saw gas at $4.40. In the next year, the energy market is going to be, who knows what it's going to be.
Right.
And if we did nothing, that plant might find out that with the cost of natural gas, it's going to peak and other things, that lo and behold, what was a loser 2 years ago might break even next year. And I think if we give them one more year to work things out, and they can get rid of this subsidy, it's a better win-win.
It's unclear to me that they would get rid of the subsidy with a partner. I don't think they would necessarily find a partner that would be lucrative enough to get rid of that subsidy. I don't think
That's
that's
what
what
it's-
The proposal was
yeah.
to incorporate the impact, the economic impact of the, so presumably would lower it. I mean, that was what the plant's bill.
PUC.
If they told us tomorrow that they could sell it at market rates,
Well, they wouldn't even need
They
us.
wouldn't need us.
Yeah.
That's right.
a year.
But that's what the PUC decides. We don't. The PUC, there's a whole criteria on their value to the grid, their price, the price differential. It's above our pay grade.
Saying the same thing, and you said it more clearly.
Okay, but, well, I think at this point, we are not gonna get to Act 250, which, well, we're keeping Ellen here anyway. I'm hearing we are willing to give an extension of 1 year to 2025 for them to bring, and doesn't the original extension, Ellen, say they need to bring us a proposal?
Yes, last year's bill did require that the owners of the plant report back to you with a proposal January 1, 2023.
Okay, so we move that up to 24 and we give them an extension to 25? Does that work for the committee?
an
Yeah.
extension of the rate.
1 year.
1 year.
What's the rate deadline right now, Ellen?
It expires on November 1, 2024.
Oh, right, okay.
To 1 year. Senator Bray.
So this comment's 5 minutes old, but I think it was along the same lines of 1 year, because I would worry if we didn't do any extension, they might say that we have so little of a guarantee that we're hamstrung in finding a partner. And if that year that's passed since we last talked about it was enough for them then we're giving them at least as much ability to negotiate in the marketplace to find a partner now, as they had a year ago and they were happy with that.
But this year they came in and said they weren't happy with it, that they
Yeah,
needed this
well-
extra time. in order
Right,
to
well,
be
they
able
were
to
saying
have
that
it
they
work.
can't get anyone to agree to go with them unless they knew they were gonna be able to be viable for 10 years. So we're gonna, I think, Ellen, can you draft that up really quickly? And now we've got 15 minutes. And there's no way, we need to do the S53 amendments if we can get Abby maybe we'll just take a break. Ellen can draft that up for the 1 year extension. And then we'll come back, we'll vote that out. So we'll take can you do it in 10 minutes?
Yeah.
Yes, you can say the date, okay. If you can do that, or can we vote it now and take a 10-minute break? Are you ready?
We could vote it knowing the language is coming unless we need to read it.
No point reading a legislation before we
Yeah.
vote on it, is there?
No, that would be backwards.
Just that.
Come on, you guys.
Okay, we're gonna take a
I think we
10-minute
can read
break.
it.
We need it.
Yeah.